Thank you. Please be seated. Good morning. We're here for oral argument in case numbers 1CA-CV160388, Andrew Muscat et al. Versus Creative Intervisions LLC et al. Council, a couple of preliminary matters. Please remember these proceedings are being video and audio recorded, so we'd ask you to please identify yourselves and your clients as you begin your arguments. Each side will have 20 minutes. Appellants, counsel, you're responsible to watch the clock and reserve what portion of time you desire for rebuttal. Also, keep in mind we've read the briefs, have had a thorough discussion of the case in the conference. In addition, hopefully both of you have received the court's questions that were sent, and by no means are you limited to discussing those questions. In fact, we would ask that you also consider focusing on what your interpretation would be of a cognizable injury in this case as it relates to these facts. So with that, counsel for appellant, you may proceed.
Thank you, Your Honor. Dennis Seaver and Robert Butler on behalf of the appellant plaintiffs in this matter, Andrew Muscat and Marcy Berman. And if your permission, Your Honor, I'd like to keep track or reserve approximately 5 minutes or so for rebuttal. And may it please the court, because there is a question as to whether or not a duty was owed by Creative Intervision, I'm going to address that issue first, since there must be a duty owed before Andrew can have a viable cause of action for negligence in this case. And we believe here there are several bases upon which a duty can be found. First, there is a duty based on contract, and the contract we refer to is going to be the individual support plan that was prepared by Creative Intervision along with Arizona Department of Economic Services on behalf of Andrew, specifically for the purpose of providing not necessarily treatment for him, but to provide supervision for him, especially when he was out in public. Given his prior criminal act, when he was released on lifetime probation, he was put into the group home with the understanding that he could not go out in public without there being someone with him at all times, and specifically because of the nature of the prior criminal act, which also occurred in the bathroom, he was not supposed to be unsupervised in a bathroom out in public. So those specific requirements were put into the treatment plan or the individual support plan for Andrew. That was basically a written agreement between the state and Creative Intervision for Andrew's supervision under the group home agreement. And in this case, Andrew clearly would qualify as a third-party beneficiary because he's the only person, obviously, that's to benefit from the services that were being provided by Creative Intervision.
So, counsel, it seems obvious that duty would include protecting him from physically harming himself, from harming others, the third person who was in or was harmed here. What about protecting him from harming himself in the sense of being prosecuted for a crime?
Well, I believe if you look at and I'll go read it to you, Your Honor, Judge Gates's sentencing order as it relates to Andrew, where she noted that one of the purposes of this agreement, and this is page 7 of the sentencing order, where she specifically said one of the purposes of the agreement was to prevent Andrew from recidivism. So it is clear to protect him from his own criminal conduct.
I understood, but does that create civil liability? That's the question. Does that mean that that your client was injured? I mean, received a cognizable injury, whatever. That the scope of the duty included protecting him from committing a crime and the results of that crime. Is that, and what case law supports that?
We believe, yeah, based on the contractual obligation, given the circumstances surrounding his prior acts, as well as the purpose of the individual support plan for him to prevent him from being out in public so where he could potentially reoffend, that certainly it was there to protect him not only from just reoffending, but they knew since he was on lifetime probation, that could be revoked and he could be put in prison again. Clearly, that is something we consider to be a cognizable injury.
Well,
8
let
years
me
of...
follow up on that, because I want to separate the question a little bit from duty if we can. I know you're being faithful to our request for you to talk about duty, but following up on this cognizable injury issue, separating it from duty, what authority supports the proposition that there is a protected or compensable interest in being free of prosecution, conviction, and imprisonment for a crime you committed?
To be quite honest, Your Honor, I have not been able to find a specific case on point that relates to someone bringing a cause of action for being imprisoned. But I have to say, under the very unique circumstances that we have here, that is not to say that there shouldn't be a cognizable injury. And, of course, we're asserting that there is a cognizable injury given these particular facts.
I mean, if he had been acquitted, I think you'd have a potentially different issue, but I'm having a hard time with the notion that an admitted criminal act can be a cognizable claim for damages.
Under the circumstances here where you have someone with diminished capacity, we believe that the jury would be in a position to determine whether or not he understood the nature and extent of his actions and whether or not he was able to control his actions. And it would be up to the jury to say if he was unable to do that and the imprisonment that he suffered was as a result of the failure to properly supervise Andrew, then yes, there should be actionable injuries in this particular case because he is sentenced now not only to 2 years before he was in Department of Corrections custody, but 8 years of Department of Corrections custody.
Is there an analogy to a legal malpractice claim where the asserted damage is that the defendant was imprisoned?
I believe there is, Your Honor, although that's something that wasn't brief, but I looked at that just recently.
Yeah, but there's a big catch to that because the defendant, now plaintiff in the malpractice action, has to demonstrate through Rule 32 proceedings or something else that he wasn't in fact guilty of the offense.
And in this particular case, Your Honor, we believe that a jury has to address the issue in terms of his ability to appreciate and understand that, and that kind of factors into the whole situation of the wrongful conduct rule and whether it's superseded by basically Arizona's comparative fault situation. Or
Counsel, and granted, the complaint presents compelling facts, no doubt about the situation, but don't you, I mean, wouldn't this potentially put this on collision course between the criminal law system and the tort system, in the sense that to say that a person, and I'm not just your client, but anybody has and I'll read from the restatement, a legally protected interest in not having that interest invaded. They have a legally protected interest in not being prosecuted, not being, sentenced to prison, those types of issues. Is that what that means? Is that legally protected interest can mean that if somebody's in charge of me, I have a legally protected interest in making sure that I don't go to jail. And the criminal side is, you go to jail if the prosecutor says that they're going to file charges and convict you. How do you reconcile those two?
Well, first off, the criminal system is completely separate and apart from the civil system. And in this particular case, we don't have any crossover in terms of the parties, so there's no collateral estoppel effect for what was occurring in the criminal case. This is not a claim that would be governed by ARS 13807, where we're bringing it against the actual victim, and therefore they can say, well, you can't deny any of the underlying acts giving rise to the offense. So here we have a. I'm sorry, Your Honor.
No, go ahead. But he pled guilty. He pled guilty to intentionally or knowingly committing these crimes. Correct.
Correct.
And the Rule 11 process in the criminal context did determine that he was competent to stand trial. So when we talk about, you've got somebody that's intending to supervise because and I think you said he lacked the ability to understand and appreciate the nature of his actions. And then we have a criminal court that says, yes, he did. How do you rectify those two positions?
Well, from the standpoint of the Rule 11 process, one, initially he was found not competent. He was also found competent but medically dependent, and then he was found competent. So obviously they're all over the board in terms of that finding. Ultimately, yes, he did plead guilty to the charges. But again, I think we're dealing with two separate issues going on here. Criminal is to punish Andrew for that particular act. We're on the civil side where Andrew is now seeking compensation for the failure of Creative Intervision and its employee to properly supervise him and put him in a situation where this whole thing resulted because of their failure to properly act. And if we want to address it from a public policy standpoint, and we're looking at, okay, yes, Andrew obviously committed a crime, but under the circumstances, he's deaf, he's got autism, he has got all sorts of learning disabilities. He simply is not in a situation where he can be out in public on his own, and Creative Intervision left him there all by himself in complete violation of what was supposed to occur pursuant to the ISP in his favor here. So bottom line is, if he cannot bring a cause of action for his particular injury, which is the imprisonment, you're essentially saying to Creative Intervision and people in similarly situated, hey, you know what? It doesn't really matter what your obligations are. You can shirk your responsibilities, and so be it. If your custody is now, or your ward is now somehow in trouble, you get to walk away from it scot-free, and that's exactly what's occurring here.
I don't think any of us believe that Creative Interventions walks away scot-free. I think they have liability to the minor who was the subject of the molestation. So when you say scot-free, I'm not sure if I agree with that. Can you address that issue?
I'm not sure that there was ever a claim brought by the minor in this particular situation.
You would agree with me that there could have been?
Could have been, true.
Okay.
But that's only one aspect of it in terms of what's going on here, because again, from a public policy standpoint, Creative Intervision is being paid taxpayer money to do what they're supposed to do, which is to have somebody with Andrew when he is in public, and more specifically when he is in a bathroom. So now we're basically saying, well, okay, you got taxpayer money, you didn't do what you were supposed to do. So now we have even a worse situation. They've gotten money for doing stuff they didn't do, and on the tail end, now we're, as the taxpayers, are paying for Andrew's extensive incarceration under the circumstances.
Could you just, maybe you're going, I'd like to know your thoughts on the vulnerable adult statute and how, because I'll just tell you, I was concerned somewhat in the fact that the trial court didn't address it in it specifically. I mean, it's mentioned or referenced briefly at the outset, but it's not analyzed, and I don't see a whole lot of statutory analysis by the parties in the briefing. But correct me if I'm wrong on that. What is an injury under the APSA?
Well, it's not.
Is it different from the injury we're talking about that we just got through discussing the last 5 minutes?
Well, it's not defined by the statute itself in terms of, this constitutes the specific injury. Now, they do talk about saying certain things that will constitute neglect, and one of them is unreasonable, I don't want to say incarceration, but unreasonable confinement. The other one is injury caused by neglect. The question, of course, becomes, what is the injury? And our position is an injury is something that occurred here where now he is confined unreasonably, in our opinion, based on the circumstances, because they failed to provide the adequate supervision.
Wait, how
so
can that be
is an injury.
Unreasonable confinement when he pled guilty to the felony offense that required the sentence?
Well, it's unreasonable from the standpoint that it never should have occurred because of the failure of Creative Intervision to provide the supervisor to prevent him from doing the very act which was clearly foreseeable pursuant to the ISP.
But going back to the statute, how would you interpret it then? Do we turn to Webster's to come up with injury, the definition of injury? Because there needs to be one. I mean, there needs to be. It's not in there. There's no definition of injury. There's no definition of life or health either.
Right, and to me, if you're going to talk about an injury to one's life, certainly someone's confinement for an 8-year period of time plus 2 years prior to the DOC sentence, that is certainly an injury to one's life. I think we'd all agree that confinement like that is an injury. Declaration of Independence talks about life, liberty, and the pursuit of happiness. Well, Andrew's been deprived of both liberty and his pursuit of happiness. And that also would look at the jury instructions on damages when you look at hedonic damages, and you can sit there and say, well, there's been a diminishment in the quality of his life based on what it was before the incident and based on what it is now, especially during his period of confinement. So we believe that would be one of the arguments. And secondly, the Protective Services Act is intended to be a remedial statute, so it says these remedies are in addition to any other remedies that are out there pursuant to common law or other statutory provisions so Andrew can avail himself to that particular benefit, that this is remedial. And obviously the goal is to make sure that if someone who's got Andrew's severe disabilities is provided adequate protection, and he is not neglected like he was in this particular case. And as a result of that neglect, clearly it's our position that there was, in fact, a cognizable injury, which is the subsequent incarceration for Andrew for this significant period of time. And may I reserve the rest of my time, Your Honor?
Any questions? Yes.
Okay, thank you.
Yes. Mr. Metzger.
Good morning, Your Honors. Robert Grosso. I represent Creative Intervisions. I'm going to try to, because I have another defendant in the case, reserve at least half the time for Mr. Metzger, if I could.
I apologize.
In this particular case, Your Honors, I think it's important for me to say this at the beginning. I think all criminal defendants who are found competent to stand trial and are properly convicted of a crime should be absolutely barred from seeking financial compensation for their proper convictions. And I think the court can get there in this case in a couple of ways. The court expressed some interest with the questions, and I thought they were good and helped frame the issues concerning duty and then whether or not there's a cognizable injury in this case. With regard to duty, I would say that the nature of duties depend on the claimed injury. If Mr. Muscat was being transported to a doctor's appointment and there was an automobile accident, the nature of the duty would, of course, be that the driver has to drive reasonably and prudently, and if he suffered some compensable injuries in that accident, he could recover. In this particular case, unequivocally, we can say this.
Counsel, can you stop for a second? Help me understand Gibson, which some of us struggle with understanding all of Gibson, but I thought it says, our Supreme Court has said, you don't look at the facts of the particular case, you look at the relationship between the parties and what was the duty beforehand. And now it seems like you're suggesting that you look at the facts of a particular case in order to form duty.
No, I think there are cases, Your Honor, where duties are recognized, but because the person does not have a compensable injury or damages claim, the case can be decided on that issue. And I think that's where the trial court went here. The court went quickly to there's just no cognizable injury or compensable damages. I can give you a quick example of that in Arizona law. A person negligently runs a stop sign and kills a woman. The woman's not survived by parents or children. She's survived by a sibling. Even though there's a duty in that case, the court would decide it based on there's no compensable injury, because under the wrongful death statute, siblings can't recover. Here, I think the court could hold as a matter of policy. I think this is a rare exception. Appellees did not owe a duty to Mr. Muscat to prevent Mr. Muscat from committing a crime. And as Judge Campbell properly pointed out, this does not absolve Creative Intervisions, because Creative Intervisions could have a duty based on its obligation to supervise to protect the child from what Mr. Muscat did. The question before this court is whether Mr. Muscat, as a matter of policy, whether we can say that a custodian has this obligation to the ward to prevent the ward from committing a crime. And I'll say to you, the answer to that has to be no, for public policy reasons.
But why do we have to make it that difficult? I think melding the concept of duty and cognizable injury makes it unnecessarily difficult. We know that a cause of action for negligence must require proof of cognizable damages. Why isn't simpler, cleaner, and the same result to view that prong?
Your Honor, I couldn't agree with you more. That's where the trial court went. I was offering these comments because I felt that this court, through the questions, was really focused on the duty analysis. So I apologize if I did get us off track.
Not your fault.
They start moving into it, it would violate public policy to impose that duty because it would allow a plaintiff to shift liability for his crime. And I think this is important. An Arizona statute says the purpose of criminal penalties is to impose just and deserved punishment for those who threaten the public peace. ARS Section 13101, Subpart 6. It would violate public policy for a criminal defendant to use the criminal justice system to shift liability for a crime they were convicted of and to seek money for something that the criminal court has said was just and deserved punishment. We can't have those collateral attacks. When this court asks, what policy should we be looking at? Well, this court should look to the importance of the criminal law and the need to respect the boundaries between the criminal law and the civil law. I think this point is important. I think it was something that you were suggesting, Judge Brown. There is a section in the restatement. It's quoted by the Seventh Circuit in Levine versus Kling. The court quoting the restatement second of tort section 1 said, tort law provides damages only for harms to the plaintiff's legally protected interests, and the liberty of a guilty criminal is not one of them. And I think that adequately sums it up. It's just tort law is not aimed at compensating a criminal for that criminal's commission of a crime. And it can't be for the countless policy reasons that we've talked about in the briefs. If you recognize that sort of a claim, you would, in essence, be encouraging and condoning criminal conduct. Criminals could make the decision to plead to longer sentences because it could lead to a larger monetary benefit. You would establish their damages claim if such a cause of action was recognized. Given my limited time, I want to quickly address the Tug Valley case. I think it is factually very different. The plaintiffs were not suing in that case for their incarceration. They were suing for bodily harm caused by their addiction to prescribed drugs. So they had a cognizable injury or claim. So I think that case is different. We were not able to locate, and we exhaustively researched, any case in the United States that has this fact pattern where a custodian was liable to award for the ward's legal penalties when that ward was declared competent, pled guilty, and found culpable, without question. So there just is no reason to recognize that cause of action. And I might go to the APSA question that the court had, because I know Judge Brown was interested in that. And again, I think the simple answer there, and I think it does play into what Judge Downey was pointing out, the analysis can be simple if we go back to that quote I read a little while ago from the Seventh Circuit. The APSA statute was intended to be remedial and supplement cognizable causes of action with compensable harms. So the analysis really isn't any different. Just like common law tort law doesn't provide relief in a case like this, there's no evidence that the legislature intended to allow criminally competent criminals who plead guilty to sexual molestation to recover under the APSA statute. And I would respectfully suggest, I have a lot of experience with this and its legislative history, that is clearly not the intent of that statutory scheme. You cannot interpret the term injury in the APSA statute to include a criminal's incarceration. And I would say this, incarceration is not the criminal's harm. The incarceration is the penalty or debt that society and the criminal justice system has imposed on that criminal for their wrongdoing. It is neither fair nor reasonable to call that a harm. That's the consequence that all criminals face when they commit crimes. So in this particular case, I think the analysis under APSA fails for the very same reasons that it fails under standard tort law. At the end of the day, Your Honors, I think this case can be easily decided the same way the trial court found it, that there was no cognizable injury. Committing a crime isn't a cognizable injury, and it's not compensable damages for countless reasons for somebody to claim that their incarceration, that they were given through the criminal justice system, is a harm. And unless Your Honors have any questions, I'll allow Mr. Metzger some opportunity.
Any questions? Thank you. Thank you.
Thank you, Your Honors. Nathan Metzger for Appellee Temetayo Akande. Things have been covered pretty extensively, but I'm going to try to touch on some things I heard come up during argument. One was, I think, Judge Downey, you asked whether any of us had found any cases that find that a person serving a sentence or getting a criminal punishment, it has ever been found to be held as an injury in a tort context. And I heard Mr. Seaver admit that despite exhaustive researching, even they have not found anything like that. His only explanation for that was that these are unique circumstances in this case, and I would respectfully completely disagree with that. If we imagine, if this court were to rule that to serve a righteous penalty, a righteous sentence, not wrongful incarceration, but rightful incarceration, that's an injury, that's a tort damage, then all of the tens of thousands of people who are serving criminal penalties today in DOC have ready-made damage claims in tort cases. All of them do. And all it takes is some creative lawyering to come up with reasons why somebody's responsible for them being there. And that's not unique whatsoever. I mean, all of these, many people would have arguments that they weren't as good at regulating their conduct, or they were at a Boy Scout camp and they did, their camp counselor didn't keep them from setting fire to the clubhouse, or all of those things. So these are not unique circumstances, and in fact, we have found cases that find the other way, and we did put them into our response brief. There were several cases that were cited where a patient's getting treatment. The closest we've been able to find is, say, a patient getting some mental health treatment, and they claim that the doctor either should have put them into the hospital or should have not let them out of the hospital because the doctor knew or should have known that they would do something bad. Those cases are pretty much on all fours, and they're the closest thing we've found. And those cases that we find universally say, no, you cannot use a criminal penalty as a part of your damage claim, and it would be against public policy to allow such a person to try to turn around and then be compensated for that by the person who didn't, put them into custody or keep them from getting out. The only argument that I saw in the reply brief to distinguish those is to say that those cases are factually different because they don't involve custodian, as we had in this case, someone who's there to watch. But logically, it's not distinct, because in those cases, if you look, they are talking about either the failure to put them into custody, or a negligent failure to put them into some kind of hospitalization in custody, or the negligent letting them out. So there is no distinction. And they have not found a case that holds that a person that is under treatment or has a diminished capacity of some kind can turn around if they commit a crime and use that as the basis of a tort penalty against someone who was responsible to care for them. They haven't found that because I would argue there's no duty there. There is and I agree with your Honor, Judge Downey, and I think you and Mr. Grasso sorted that out. Clearly, the more I've chewed on this, and the more you chew it and chew it and chew it, it really gets down to there's no cognizable injury. I mean, that's the cleanest, simplest way to look at this, and why we don't see any cases that have ever allowed this, because serving a righteous criminal penalty is not a harm. You're a debtor at that point. You're not a creditor. You're serving, and I think Judge Brown had pointed out that there seems to be, we put ourselves on a collision course with the criminal court if we allow this kind of a collateral attack, and we do. The reason the courts don't get into conflict is because we don't see these kind of claims getting made, where someone claims that they're entitled to compensation for their own criminal conduct. And we see in the minute entry that was attached, Judge Gates specifically stated, he pled guilty, and she specifically stated in the minute entry, the sentencing, that he was culpable. He is culpable.
So counsel, what I think I'm understanding is the key here, at least under these facts, is the conviction. Because what if in a different case, somebody, or Mr. Muscat, what if he would have gone to trial and had been acquitted? Could your client potentially be liable for all those costs, those defense costs? That would be. Are you saying that's a different injury?
I think in theory what you're saying may be true. That if he were prosecuted and then found not guilty, But then, we are talking about a lot of questions. Is he really not guilty, or did he just get found not, they couldn't establish it to the burden of proof necessary in a criminal court? But at least in theory, yes. Let's say the court in the criminal proceeding actually found him. In rare cases, they will make an exculpatory finding that he's not responsible. I think at least in theory, there might be a claim there. But here we have a person who pled guilty. There's no doubt, they can't deny that he was volitional, knew right from wrong, and pled guilty to the crime and was found culpable.
What if through the Rule 11 process he was found not competent, not restorable, and then placed in ASH, the Arizona State Hospital? Does that change your analysis at all?
If he's placed in ASH, then maybe that's, where he would have belonged to begin with.
And you can make that argument, but he was out in the community on probation, free to do things under some pretty strict supervision.
I think he was given the opportunity to do that. And there were ideas that he would be supervised, he would have the opportunity to try to live such a life. And it turns out that that really isn't plausible for him, apparently. I don't know. But, again, when we're talking about a scenario where he does not plead guilty and is not found culpable, I think the facts are distinct to what we have here. I guess that's about.
I know we led you to believe we were focusing primarily on duty, and today we're showing a lot of interest in the cognizable injury claim. And so this is a question that I asked appellant's counsel, and I won't be surprised if you haven't read the case law. In legal malpractice cases where a now plaintiff is claiming that his criminal defense lawyer committed malpractice and his damages were incarceration. Are you familiar with that line of cases? Because my recollection is that that's not a cognizable injury unless, I'm not sure you have to show actual innocence, but you have to basically show more than that either it's been adjusted through Rule 32 or set aside. I mean, you can't just mount a direct claim for damages from incarceration in a legal malpractice.
Yeah, I will confess I'm not
right.
really familiar with those.
I'm obviously not either.
But I would say, this opens up a can of worms. If we allow this case to go back to the trial court, it certainly opens up a can of worms where part of the defense would then be in the civil tort case. Did he get adequate counsel? Did the judge wrongfully accept a plea? Was there a failure to mitigate by accepting a plea, to pleading guilty when really he's claiming that he doesn't have capacity? It really is a can of worms that once he has pled guilty and the court found him culpable, she stated in one of those pages, he is clearly culpable. There is no case law that we have been able to find in any of the 50 states that have predicated a tort claim on that kind of, on incarceration, rightful incarceration, and rightly so.
In referencing, I should have asked this earlier, but referencing the court sentencing minute entry, is everybody in agreement that we can consider that as taking judicial notice of that document? And you can address that in rebuttal, but you've asked us to take judicial notice, I believe, of the fact of the sentence, so I don't know that we would necessarily piecemeal and only look at one part of it. But if you want to object to that, then make your objection known.
It's in the record at this point, I believe, but
I don't think it's in the record.
Yeah.
I don't think it's in the record, not on the record on appeal. The sentencing, is it? Or?
I don't believe
okay,
it is.
but anyway.
I think you're right. I apologize.
Okay.
I don't have any thoughts on that, Your Honor, actually.
Okay, thank you.
One thing, Your Honors haven't brought up this wrongful conduct rule and the terminology we used. Are you interested in that? Because I am a little concerned that there's two different formulations we're talking about.
Well, I think there's a lot of formulations
Yeah.
of the wrongful
But
conduct
the
rule.
wrongful conduct rule potentially triggers constitutional provisions and other provisions that would be more cumbersome. But if you want to talk about it,
Well, one thing I just wanted to make clear is that, they're referencing wrongful conduct rule as the concept that a defendant cannot use the fact that a separate crime is being committed by a plaintiff at the time that a defendant potential defendant tortiously causes an injury to them, that a defendant cannot use that as a bar to the tort claim. And we don't disagree with that. We agree that that formulation of the wrongful conduct rule Arizona does not allow that. Arizona says that a defendant cannot use that as a bar. We totally agree with that. I just want to make sure the court understands that. What we're saying and what our formulation and what we're talking about as the wrongful conduct rule is that individuals convicted of crimes cannot impose civil liability on others for the consequences of those crimes. That's what we're talking about when we talk about a wrongful conduct rule. Just so the court's clear on that, because there could be some confusion. So that's, and I think it's already been touched on. I did see in the briefs, the appellant's briefs, that they keep talking about how our arguments would absolve our clients, and I guess that's been addressed. We don't see it as absolution or absolving, because the minor child, still being a minor, could theoretically still bring a claim. And we're not agreeing that we would be held responsible for that, but at least that would be a cognizable claim, in theory, if the victim did bring a claim. Anything else that would be of help?
No.
Thank you, Your Honor.
Briefly, Your Honor, on the sentencing order and whether or not the court can consider it, I believe both sides had referenced it pursuant and said that the court could, through take judicial notice of the sentencing order. So I believe that that's appropriate for you to do for the entire order. You don't have to parse through it. As to the issue that somehow we are asking this court to open up the doors of the courthouse to all sorts of litigants who have been thrown in prison, that's simply not the case. Given the uniqueness of the facts in this particular case, given the individual support order that, individual support plan that Andrew was under and creative intervention was supposed to follow, where he was not supposed to be out in public without a chaperone, where he was specifically not to be allowed into a public restroom, you can, under these particular facts, simply say a duty was owed, but it's a contractual duty and is specific to the agreement that was reached between the Department of Economic Services and creative intervention that says when they breached the duty by allowing Andrew to go into that bathroom alone, not supervised like he was supposed to be, that is how narrowly you can draw the duty in this particular case. So not everyone that's ever been thrown into the prison.
Doesn't avoid the cognizable injury claim, because as opposing counsel pointed out, you could have a wrongful death claim where there is no compensable injury. I mean, so that gets you past duty, but it doesn't get you where you need to be for all the elements of a negligence claim.
Well, at this point, Your Honor, obviously no one has been able to find a case that specifically talks about whether someone's incarceration in and of itself is an injury for which a negligence claim can be made. We're making that argument here, given the very specific facts that occurred here and given Andrew's very diminished capacity. Even though he pled guilty to this, it is clear in Judge Gates's sentencing order he had severe disabilities. He did not understand exactly what was going on here, enough to have to plead guilty to this matter. However, he never should have been put in this particular situation, and it was all done because of the failure of creative intervention and its employees to provide adequate supervision of Andrew. And it goes back to the issue of, okay, is the criminal punishment in and of itself a cognizable injury? And we would assert, yes, this is a severe restriction of Andrew's liberty interest, his ability to, as I said before, liberty and the pursuit of happiness. He is now serving another 6 more years in Department of Corrections. He has been significantly impacted, and there are mental issues that he will have as a result of this, the anxiety, the angst, the loss of consortium with his mother, all of those things that arise out of that, as well as the hedonic damages that he suffered because of the incarceration that he is undergoing at the present time. And I know, obviously, this is a tough case, and we wouldn't be here, I don't believe, but for these very specific facts and this very unique situation. But under this type of situation, Arizona, the public policy is for injured parties to have their day in court and to be able to get compensated for for their damages. And we believe under these unique circumstances, Andrew clearly should be entitled to seek compensation for his injuries, which, similar to someone being falsely imprisoned, would include the fact that he has been deprived of his liberty He's not able to go wherever he wants to go because he's in a prison system at this time. So those are severe and significant restrictions on his conduct. And I'm not sure how much more you want to go into the duty issue. I think that's probably been addressed fairly well at this point, and I think you guys are focusing more in on the cognizable injury issue at this time. So unless you have any questions about that on the cognizable injury, I will leave it.
Any further questions?
Okay. Thank you, Your Honor.
Thank you. Counsel, to all three of you, thank you for your excellent arguments. The court will take this matter under advisement and issue a decision in due course. We'll take a brief recess to set the courtroom up for the next argument.